SJC-12515, Jillian Calixto, and another v. Heather Coughlin and others.
We're here for you.
Mr. Rosenberg, when you're ready, then you should understand that your case is equally important to us.
Thank you. Good morning. Chief Justice, Associate Justices, may it please the court. My name is Nick Rosenberg. I represent the appellants who brought the claims below individually and on behalf of a putative class of similarly terminated employees. Before the court are two main issues. The first, whether the employer's non-payment of 60 days' pay under the Federal WARN Act is actionable under our Massachusetts Wage Act. The second is whether the WARN Act's remedy provisions preclude a state common law claim for breach of fiduciary duty for the corporate officers in causing the company to incur WARN Act liability.
If I could begin you with the second claim.
I would like to address that very
But help me. Let's assume you are right. Assume that we are not, I'm not sure we will, but let's assume for the sake of the question that we will not take the federal, the absence of a reference to the common law where it mentions statutory and contractual as suggesting federal preemption over common law claims. Okay, let's assume you get that. How do you have a breach of fiduciary duty where your clients are the employees of this company?
So, as a first issue, that argument was not raised below or in the briefing by the appellees. But there's no opinion that we don't state a claim.
It's still sort of a problem because generally the employees, there's not a fiduciary duty of the officers of a company to the employees of a company. So I don't know what to do with
Correct,
that.
Justice Gantz. This is a Delaware corporation, and under Delaware law, creditors of a corporation have standing to bring a derivative claim. In the Production Resources versus NCT Group case, which is 863 A. 2nd 772, Delaware Chancery in 2004, establishes that as creditors, and these employees and the putative class are creditors as judgment creditors in the federal case have standing.
But your claim, I gather, is that they breached their fiduciary duty by not giving 60 days notice and therefore imposing upon the company the burden of having to pay the 60 days of wages, but they weren't creditors at the time that the officers engaged in their conduct.
Correct.
They're creditors only because of the conduct of the officers, not.
Correct, and it is a bit circular, but from a legal standpoint, at the moment the employees become creditors under Delaware law, they have standing to bring a derivative claim. The company or the officers, in causing the company to incur liability, whether it be under the WARN Act or violation of a securities law. It's not unusual or novel for a derivative claim to allege that officers and directors have caused a company to incur significant liability. Now in this case, it is a little unusual because that liability is a liability that would go to the company and then potentially to creditors, including the employee plaintiffs. However, as a legal matter, as I said, under Delaware law, it's fairly clear under the Production Resources case, they have standing as creditors. They stand in the shoes of the company, not as employee plaintiffs, but as the company. And the company can assert a claim against its officers and directors for causing the company to violate a federal law that caused the company to incur a significant judgment. So that's how they have.
So help me go back to the initial point you made is nobody has discussed this. It wasn't raised below. What do we do with it?
It was not raised below, so we're entitled to proceed in the Superior Court if this matter is remanded for the other reason as it not being preempted by the WARN Act. As you began, Justice Gantz, if the breach of fiduciary duty claim is not preempted by the WARN Act, which we argue it's not, there is no preemption. The appellees haven't argued the actual elements of any formal preemption, and as we know for preemption, it's either preempted by federal law or it's not. Calling something an end run isn't a legal argument.
Well, but the WARN Act is the exclusive remedy for WARN Act violations, right?
The WARN Act provides within the Act that those provisions are the exclusive remedies, although the Act at Section 2105 says.
But the liability, the responsibility for paying comes from the WARN Act. There would be no other responsibility to pay this except for the WARN Act requires it to be paid, right? There's they have no common law obligation to pay this.
I'm sorry, who is they, Justice Cocker?
The company. The only reason this liability to pay this 60 days comes exclusively from the WARN Act, right?
Correct.
So I don't understand how you can get around the exclusive remedy provision when the WARN Act is the only thing that creates the obligation. It's not like we have a separate tort here.
Well, in the case of a company that violates a securities law, the damages for that violation comes from the securities laws.
Right.
But the company may proceed against the officers and directors under common law and Delaware law for breaching their duties and causing the company to incur liability.
If the action violates something else, not if it's, I mean, everything is dependent on this being a WARN Act violation. You lose me on this. I understand the first issue, but I don't get how the second issue isn't just a WARN Act violation. You're adding it, it's a breach of fiduciary duty to violate the WARN Act, right?
It's a breach of fiduciary duty to conduct yourselves as officers and directors in a negligent manner or willfully negligent manner.
Not paying the WARN Act.
By causing the company to incur the damages. Not the not paying. Again, the Wage Act claim is seeking individual liability under our Wage Act against the officers and directors via our Wage Act. The breach of duty claim is a derivative claim by the company
Not for being negligent and not paying the WARN Act.
Not for them not individually paying, but for them acting in a way that allowed the company to incur that liability, not directing the company to pay it, not taking measures to prevent the payment, or requiring that the company conduct business for 60 days so as not to be liable.
Of course,
it's not just the payment.
Of course, they didn't pay. It was a default judgment. But going back to this issue that Chief Justice Gantz raised initially on the preemption, but so there's the appellees are saying you waived the issue too, by the way.
Right.
But both of you are saying
that was the issue I would like to address.
Yeah, and
first, if I may.
Yeah, but just if I could just deal with the issue that Justice Kafka just brought up for a moment. So the WARN Act talks about an exclusive remedy not intended to affect other rights and remedies, but there seems to be an exception within that, and the exception is pretty specific. It's for statutory and contract issues. So not only do you have an exclusive remedy, but you have sort of an exclusive remedy because you can, it's okay if it deals with statute or contracts, and here you've got a common law action.
Right.
So even if there's no preemption, and I'm not sure I see the preemption either, even if there's no preemption, how can you bring this Wage Act case here when the underlying gravamen here is the WARN Act?
Again, and it's a fair point, if you read it literally, the exceptions are for contracts or for statutory, but not common law, or could you read that to suggest there are exceptions and they enumerated two, but that was not meant to be exclusive? But I think I come back to my original point, which is the only way that a federal statute can preclude a state common law claim is via preemption. And preemption is a specific doctrine, and the appellees have not raised the elements of preemption. And if you follow the preemption argument as we laid out in our brief, there is no preemption. And our argument is there's either preemption or they're not.
Okay, so
the fact that federal
basically you're
statute
saying, just so I can understand, you're saying the limits in the statute, on the WARN Act, the limits on what type of actions can be brought doesn't in any way impact the causes of action that can be brought in a civil suit in Massachusetts. Is that your position?
Correct, unless you read those limitations to meet the preemption criteria. Is the WARN Act trying to occupy the field? Is it expressly intending to exclude other state causes of action? Does it meet the preemption elements? In which case, yes, that language could be used as one argument or one piece of evidence towards the intent of
But
Congress to occupy the field.
Isn't the meaning of the carve-out is to say, okay, if the state has its own law saying you owe 60 days for this type of stuff, we won't preclude enforcement of that. Or if the company says in its employee manual, we'll give you 60 days payment, it doesn't mean that you can bring the same claim, meaning that you didn't pay the WARN Act. I mean, at least I don't read it that way. That you didn't pay the WARN Act provision, which provides the 60-day payment, therefore you've acted negligently in relation to the WARN Act. That's what you're essentially arguing.
But if a shareholder of the company had brought a derivative claim saying the stock went down, or the value of the company went down, I lost my, not the employee plaintiffs, I don't think we'd be calling this an end run. It would be a separate plaintiff with a separate interest.
That's because it has
in the
no
matter.
because it has no relationship to the WARN Act payment.
Correct. But if shareholders said, you guys let the company incur a $2 million judgment by violating the WARN Act. This is a terrible thing for the company. We as shareholders bring a derivative claim against you for breaching your fiduciary duties. I don't think we'd be talking about this as an end
And we don't
run or
have to,
exclusive.
and we don't have to be concerned that the WARN Act does not impose personal liability? We don't have to worry about that in this analysis?
No, because the liability is from a breach of duty. It's a different cause of action. Now, if the shareholders said we're going to bring action against you for under the WARN Act or under the Wage Act, we'd be back to the first claim. But here,
Well, they're not subject to that type of compartmentalization. The breach of fiduciary duty arises out of the cost incurred by the company under the WARN Act. I mean, you can't just compartmentalize those two issues like that. The WARN Act, probably for very good reasons, and one of the amici point this out when they're talking about the faltering company exception issues, there's probably really good reasons why the WARN Act didn't provide for personal liability related to business judgment rule and all sorts of reasons. So we can't just separate those.
well, the business judgment rule would come into play in litigating the breach of duty. That may be a defense that's raised. But whether or not the plaintiff sufficiently pled the elements of a breach of fiduciary duty claim has not been challenged. What was challenged is that this was preempted, and the preemption analysis is fairly specific. If Congress intended to occupy the field with this statute or explicitly preempt other causes of action, we'd go through that analysis, and I think the result is you'd find that it's not preempted.
If I can turn you back to count one, to the
Yes.
WARN Act.
May-
If we begin to open the door to saying that that back pay are wages, do we not open the door to any employment claim where there's a finding that back pay is owed? And of course, it's never going to be paid within the time frame of the Wage Act. So are we transforming every discrimination case, every wrongful termination case into a Wage Act case with treble damages and attorney's fees?
The answer is absolutely not. And that point, that sort of slippery slope argument, was raised by one of the amicus in their briefing, and it's a fair point. But there's an easy distinction. In every single one of those examples cited, Title VII, MCAD issues, discrimination claims, common law claims, back pay is identified as a potential element of a damages award to be adjudicated based on the appropriate remedies to fulfill the intent of the act. It doesn't have to be awarded. There's no express specifics about what the award should be. Here we have statutorily, federally mandated pay in a federal worker protection statute that says 60 days pay. If you're terminated without notice, you get 60 days pay. It's not part of a subjective or discretionary damages award. It's not part of the whole sort of bundle of damages that can be awarded. It's specific statutory pay of 60 days. Like a commission, it's calculable, it's finite, and it's owed.
In 151B, I don't know whether the word back pay is specifically provided as a remedy, but it certainly is a remedy.
Sure, But it is a damages remedy, and if you look at the numerous cases we cite, like the Dewey-LaBeouf case and so forth, they talk about Warnock pay not being a damages compensation, but as being really wages. And if I can just, use one illustration on that point.
But I don't get that. If you're say you're discriminating against women in your business, and women are getting paid 80% of what men were getting paid for the same work. So we know the exact amount, and you get a 151B award along those lines. Isn't that the same as this? You violated a statute that says you're supposed to pay men and women the same for the same work. Why is that not different? Why is that different from what you're doing?
Right. I think because we have some indicia in the case law that WARN Act pay is different. That this is pay specifically at the time you're terminated for a 60-day period for the wages that you're owed for that.
But isn't
that
Justice
time.
Kafka's example actually more compelling than your case? Because in his example, the person who wasn't fairly paid actually did the work. Here, the core issue, as far as I'm concerned, on the statutory interpretation, is this payment for work performed, which you don't have. It's non-work performed.
And that point is one of the cruxes of our argument of the appellees. And I would say the courts in our legislature have never required an inquiry into how the wage was earned. In other words, we don't require a plaintiff to show or justify the labor that was done to earn the wage. And just one specific example would illustrate that point. Some employers, rather than accruing vacation time for their employees, 1 day per month, might give it at the beginning of the year. So imagine the employer who gives all their employees 10 vacation days on January 1. You have an employee who calls in sick on January 1st. They're out on New Year's Eve. And they come and they call in sick. They've accrued those 10 days because the company awards them on January 1. January 2, they call in and quit. That employer better give that employee a final paycheck that includes 10 days of accrued vacation time or be subject to violation of the Wage Act. That employee didn't work a single day or a single minute for those vacation days. What they did was, by virtue of being an employee, on the day it accrued, they earned the right and entitlement to vacation days, which are considered wages under the Wage Act.
As defined by the statute.
Right, and here,
Is that the
on the
difference,
moment an employee is terminated without notice, they have earned the right to 60 days pay under the WARN Act.
So in one example that you give, it's defined by the statute. In this example, it's not so included in the statute, right?
Well, under the Wage Act, vacation pay is defined as wages,
Right.
which would have to be earned to qualify under the Wage Act. So they're earned because on January 1st, the company grants them, even if the employee is not even there. So the point is, you don't have to be there, you don't have to be working, you don't have to work at the 60 days. That earned, as the case law refers to it, really seems to indicate that at a moment in time, you become entitled to a right to payment. And under the WARN Act, the moment you're terminated without notice, you've earned that right. And our legislature has indicated that they would like those kinds of payments to be covered under the Wage Act. I know we referred to the carve-outs under the employment statute in our brief, but there's one other place that the legislature has indicated their intent, and that is under Chapter 149, Section 183. It's sometimes referred to as the tin parachute statute. Under that statute requires payment to employees who are terminated after a transfer of ownership of a company. It was in the 80s. It was to anti-takeover and downsizing statute. It was since preempted by ERISA because of the way the payments were structured. But importantly, in that statute, the legislature provided that the right to termination pay was enforceable under the Wage Act. And if the Wage Act covers earned wages, it would be odd for the legislature to want to have those kinds of termination payments covered under the Wage Act.
All right, thank you.
Thank you.
Mr. Thomas.
Good morning, Mr. Chief Justice and Associate Justices. My name is David Thomas. I am here with Mian Wong, who's also on brief, and may it please the court, I just wanted to start by just correcting perhaps what could be a misperception from the record. We did brief the fiduciary duty issue below, It's at Appendix 38 and 39. That was part of our motion to dismiss. We had some 12B6 arguments on that. I think the reason why I wasn't really focused on at oral argument before the trial judge was because during the 9A process, Superior Court Rule 9A process, my brother dismissed 3 of the claims. There were 7 claims at stake. 3 were dismissed, which left, actually 4 were dismissed, which left counts 1, 2, and 7, 7 being a derivative count. 1 and 2 were the crux of the argument before the judge. And when we looked at the briefing, we looked at the complaint, they were based on Wage Act liability. And we mentioned the actual cites from the transcript in the briefing. My brother specifically told the judge that the issue was Wage Act liability. So we really didn't get into the issue of common law potential responsibilities for the WARN Act, and that's why it's not briefed in there. I don't think it's a preemption issue, though. And Justice Caffey, I think you stole most of my argument, but I will try to repeat it. At common law, no employee, but for a contract, has any entitlement to 60 days' notice and back pay. That's a creature of the federal statute under the WARN Act. And that statute specifically says there is an exclusive remedy. And that remedy is against the business enterprise. The savings clause at issue here in 2105 preserves only statutory and contractual rights that arise out of failure to give notice. I mean, if there's other wrongful termination or things like that, that's not going to be covered by the WARN Act. We're just focused on the failure to give notice. So if the substantive violation
Can you explain, though, you had arise out of the failure to give notice? That part I wasn't, can you explain what's that add to?
Sure, other wrongful termination. If there's a failure to give notice of termination, you have a contract, for example, or if perhaps the employer closes a particular segment and the workers think that there's discrimination or something like that, that's what that savings clause covers. And that's actually addressed in our brief below. There's a case called In re Bluffton, which is actually overturned on other grounds, but the Wage Act, the WARN Act discussion and the reconciliation of the exclusive remedy and the savings clause is discussed in that case. And that court basically states if you're focused on, if the damages you're dealing with are WARN Act damages, your remedy is in the WARN Act. And that's based on the statute. So that's why we really didn't get into all of the preemption arguments, because I don't see it as preemption. There's no preemption.
It may not matter here, but I mean, if there were indeed shareholders of the corporation who brought a true derivative action, claiming that that the officers were reckless and failing to give 60 days and therefore have imposed this burden on the corporation, would you say that that's barred?
I would say that based on a fiduciary duty,
based on a derivative action, a derivative claim that the officers acted, failed in their business judgment by imposing a substantial liability on the corporation, which they should not have done because they should have given 60 days, and therefore we want you to give us that money back because the corporation's paying.
yes, I think it would be barred. It's a common law claim. 2105 is very, very specific, contractual and statutory. Otherwise, you have to go into the business enterprise. So I think that type of common law claim would be barred.
What do you say about preemption just doesn't apply because the WARN Act is not really an exclusive remedy if the action is statutory or in contract? So the plaintiffs say, since it doesn't say preemption, we don't worry about preemption when we're dealing with state causes of action.
I think for a state contract causes of action and statutory, as stated in 2105, there is no preemption. And
I understand that, but what the plaintiff is saying, there's no preemption since there's nothing in the statute that says this is the exclusive remedy that they cover the field, because you can have a contract or a statutory cause of action. That's their position. I'm just wondering what your response is to that.
I think if we were arguing preemption, it would be a limited preemption as far as the exclusive remedy against the business enterprise. And the only carve-out to that would be the statutory and the contractual statement in 2105. So I think there's more of an implied, if there is a preemption, there's more of an implied preemption to those common law claims. Again, there's no right to 60 days back pay. And again, if there was notice was provided, there is no back pay that is owed. And speaking of back pay, I do want to make a point under the Wage Act. I mean, there is a fundamental difference between being entitled to monies based on a federal statute because an employer didn't give notice. I understand that those monies could be owed unless there are exceptions, the faltering business, the unforeseen business circumstances, or in the WARN Act, a judge can always reduce the penalty and the damages if he or she believes that the corporation was in good faith. So there can be an entitlement, but that is drastically different than something being earned under the Wage Act, because the entitlement comes from the employer's act of failing to give notice. The earned wages come from the employee's act of working the hours. And when we compare the two sort of natures of the damages under the WARN Act and the Wage Act, the fact that WARN Act damages can be reduced by the court based on good faith, the fact that they can be avoided altogether by giving notice, the fact that they also apply to benefits, which under the statute would include child care expenses, death benefits, unemployment. These aren't, and separation expenses, these aren't the types of things that this court has deemed to be earned wages.
It also can be reduced for money actually earned.
Exactly, and it's a very good point, Judge Lowy. The WARN Act itself, within, I think it's 2104, treats wages differently than back pay liability. So the Congress said we want back pay liability, those are damages, reduced by wages and reduced by other things. So when we look at the issue between the WARN Act and the Wage Act, we think, and we agree with the amicus briefs, we think that it's clear that these really aren't earned wages under the Wage Act. And if the court were to consider back pay liability, and I think the amicus briefs do a really good job at focusing on the policy arguments here, but if the court were to consider interpreting earned wages to include back pay liability under the WARN Act, which would have obviously implications to other back pay, we think it should be done prospectively in this case for various reasons. And we go over these in our brief, but I did want to make mention of them. At the time that ISIS Parenting closed its doors and then allowed a default judgment to enter, there was no foreshadowing at all under federal law that individuals could be liable under the WARN Act or the Wage Act for these types of damages. Certainly, when we look at this court's cases and jurisprudence under the earned wages in the Wage Act, there was no foreshadowing there that this could be an issue. And even further, if you look at the appendix, the federal complaint was initially filed naming two individuals, one who's an appellee now, and that one of the individuals was actually named under the WARN Act. It was amended later on after my communications with my brother, explaining that there's no individual liability under the WARN Act. That came prior to the default judgment. So that action in and of itself also gives the board of directors of the company essentially the sense that there is no individual liability here. We've got federal cases, we've got the mass SJC cases, and we have the plaintiff actually amending and pulling off individuals from this claim at counsel's request. So when that default judgment enters, if there was any thought that there could be individual liability to officers, certainly the corporation probably would have defended that case. And we think that if there's going to be a change, it would be certainly inequitable under the circumstances. I'd like to make a point about the reply brief. There is a retroactivity argument in there. I think it focuses on the wrong law. My brother essentially argues that the WARN Act and the notice of the WARN Act, that was all well known at the time of the default. That's really not the inquiry here. The inquiry here is whether the corporation had any inkling, any foreshadowing that individual officers could be liable for the corporation's actions. So again, we don't think it should be retroactive. We think it should be prospective.
For the Wage Act, when we added vacation time and others, we didn't make it prospective.
Vacation time.
This is a Wage Act claim. It's not a WARN Act claim. So
Correct.
The question is whether or not it's under the Wage Act, and the Wage Act has been around for a long time. It's not new. Since when do we sort of say an application of the Wage Act can only be done prospectively?
I think when there is, as we went through in our brief, when there's no foreshadowing that the dollar amount that we're talking about, whether it's separation pay, whether it's something else, could possibly be earned wages under the Wage Act, and in conjunction with the federal.
That's a separate issue. That sort of says you win, but the
That's what I'm angling at, Your
retroactivity
Honor.
kicks in only if you were not to win.
Right.
I just don't understand that if we indeed were to find that these are wages, the Wage Act's not new.
No, the Wage Act is not new, but it would be an expansion of the definition of earned wages within the Wage Act. And people do have to be on notice, companies need to be on notice of this when they make decisions to incur that liability. If this is going to be wages, if the WARN Act penalty is going to be wages, there needs to be some kind of foreshadowing on this. So I think this would be the time where it would be prospective. Because when we take that federal law and the case law, and again, the fact that the individual was pulled off the WARN Act count in this federal complaint initially, all of that militates in favor of this really needs to be perspective. It also goes, and I'll cite to the amicus briefs, they really do a good job at focusing on the statutes and the laws that award back pay. And that would really open up, in our mind, we agree, Pandora's box to all of these wrongful termination type claims. All that back pay, despite the fact that if you're trying a back pay case, I think arguably wages get deducted from that if they're paid lawfully, all of that gets thrown into the Wage Act.
We really haven't talked, other than Justice Gaziano's question, we really haven't talked about whether the WARN Act payment for 60 days is a wage or isn't a wage. In its simplest form, you would say it isn't a wage because it's for payment for work that wasn't done, and the plaintiff would say that it's for wages that should have been paid, so it's really wages. So which argument is right?
Well, I think our argument's right, Your Honor.
I'm shocked.
I know. So in Section 2104, back pay is referred to as liability, and there's case law we cite in a brief that refers to that more as damages, and I think it's the Phelps case from the Supreme Court that talks about what back pay means. 2104 also uses the term wages. Back pay liability, I think, is used, or liability referring to back pay is used at least 6 times. So you get back pay liability, which is the back pay, which is calculated based either on the higher of the wage rate that you had when you left at termination, or an average, just to make sure that the employer doesn't reduce hourly rates to pay less under the WARN Act. That is a measure of damages, and the Congress would not have used the word wages and liability 6 times if they were the same thing. So we don't think they were wages. Also, pushing that forward to the Mass Wage Act, there's a difference between wages, I think, and earned wages based on this court's jurisprudence. Earned wages being you have to actually perform them. Perhaps we can say that back pay is based on wages, but that doesn't turn them into earned wages under this court's jurisprudence. In conclusion, unless there are any further questions, we do believe that the decision should stand, and any change or interpretation or broadening of the definition of earned wages should be prospective. And also, for the reasons stated in our brief, we think that the issue of fiduciary duty has been waived. But again, it was briefed below. Thank you.
Thank you. And we'll take our morning break.